Good morning, everybody. Almost 2 years ago, the European Commission presented the data protection reform package. This reform, and you all know that, aims on the one hand to enhance individual rights and at the same time, on the other hand, to complete the internal digital market. In particular, by introducing one set of rules across Europe in a regulation. After 2 years, and despite the wide acknowledgement of the necessity of the reform, the new rules have still not yet been adopted. While the political parties of the European Parliament have agreed on a broad compromise across party lines, backing the European Commission proposals, and the European heads of states and government have committed to a timely adoption of the reform, one not yet there. The file is now being moved forward by the Greek presidency, which is dealing with this file as a matter of priority, and they've scheduled a high number of meetings at technical level in the Council to make progress. The Commission will continue to work closely with the Presidency and the European Parliament to make sure that strong and credible EU data protection rules can be agreed as soon as possible in 2014. Our distinguished panelists today represent a broad range of factors and perspectives, and I'm curious to hear their views about the last bugs to be fixed during the last month and how they think we should fix them. I will introduce them just all now, and then the discussion will take place in a, I would say, open, informal way between the panelists. The first one is Thomas Boué, that you see at the end with the indication. He works for BSA, the Software Alliance in Brussels, and is responsible for its public policy activities on security and privacy. Hielke Hijmans is the head of policy and consultation with the European Data Protection Supervisor in Brussels. Mario Oetheimer is there, works at the European Union Agency for Fundamental Rights, well known as FRA, and is responsible for data protection projects. Christopher Kuner is a well-known lawyer and academic specialized on data protection and privacy. And last but not least, our moderator today is Peter Schaar. He is the previous federal German data protection commissioner, and he is currently the chair of the European Academy for Freedom of Information and Data Protection. Maybe we could start with the first bug, the first question, which is the nature of the instrument. The European Parliament has backed the nature of the European instrument in the Libe Committee, a regulation. Now, there are still questions around the nature of this instrument, including coming from some member states. So,
no, thank you very much, Marie-Hélène. I think, to echo what you just said, we're here talking about fixing the bugs on the data protection reform. And I think, in my understanding, fixing bugs, meaning that, fine-tuning a almost closed deal, polishing, latest arguments, but I think we are not there yet. As you rightly mentioned, why did you do this review in the first place? I think one of the first decision was to move away from the patchwork of national laws and regulations on data protection across the 28 member states, to move away from the different and diverging interpretation of the 9546. And why did we do that? For whom did we do that? We did that for both citizens who wanted more clarity when they engage in more sort of in the single market, but also for businesses and particularly SMEs. And the idea was indeed to bring more data protection, stronger protections across Europe, but also to embrace the single market, embrace the digital economy, especially in the single markets. Now, from our perspective, from an industry perspective, bringing legal clarity, consistency, and certainty in Europe is clearly something that we commend. And we've commended the Commission for doing that from the beginning. But there are still some calls, as you said, some member states are still questioning the legal basis of the instrument, of the fact that a regulation is not the right approach, that it doesn't bring the flexibility enough for member states, that we should maybe revert back to a directive. And that, in my view, is not a bug to fix. It's a fundamental hurdle to the adoption of the package itself. And as long as this is not addressed, there's no way to move forward. Now, from our perspective, from the perspective of our companies, which are multinational companies, they maneuver the system well, with the different laws. But we're talking about helping SMEs to embrace the single market. And as long as we don't have this regulation in place, we don't have this legal certainty everywhere, I think we cannot move forward. Now, industry has been supportive, and I'm not just talking about my industry. I think industry across the board, from the beginning, has been supportive of the legal instrument, the regulation. And we've made that loud and clear. Parliament has endorsed it, but it's not our call anymore. I think everyone knows where the markers are, and I think now is time for more political decisions as to whether this is something that everyone agrees or not.
Thank you very much. Well, I take over. We have two roles: one chair, one moderator. We try our very best to combine those different, or to share the different tasks. Well, my first question is addressed to Hielke Hijmans from the EDPS. It's about the scope of the regulation. There are two legal instruments, a regulation and a directive. Should the regulation cover the public sector as well? So there are ongoing discussions in the Council, especially to exclude the public sector from the regulation. And the second question, perhaps this is really a bug, is why EU institutions are not covered by the regulation. You have the floor.
Thank you very much, Peter. I think I'm very happy to be here. That's the first thing I want to say. This is really always a fantastic conference, so I wanted to mention this is for a number of years I have the privilege to be here, and this is one of the best things in data protection, I always think. Secondly, as Thomas already said, it's not easy to speak about bugs because we are not yet there. We are not yet have a stable text everywhere. There is a stable text now which is agreed upon by the Libe committee, which is a text we as EDPS favor a lot. We think it's a really good text. There's, of course, you can at certain points be critical, but this is the way forward in general, we would say. But in Council, things are still fully open, and as we hear the sounds from Council, they are even sometimes more wide open than we thought they would be. From the EDPS, we always favored a wide scope, the widest possible scope, which means that all processing activities should be included, a wide notion of personal data applicable to all sectors. Wide notion of personal data because it's a fundamental right which is as such recognized in the Charter of Fundamental Rights, and you cannot then by a regulation limit the scope of the protection of the fundamental right. That's the one thing, but I was mainly asked to talk about the sectors that should be included. All sectors should be included. That would be the best way forward. We were not happy initially by the fact that police and justice was put in a different instrument, a directive, which in our view harms the quality of the direction, of the protection. However, we consider that at this stage, I think a fait accompli. This is not one of the last bugs to be remedied. It's just there, and it does not make sense if you want to make progress to question this policy choice by the Commission made 2 years ago. Something different is the recurring discussion. It comes back all the time in different notions to exclude the public sector, or maybe large parts of the public sector. An argument to do this is that the instrument of regulation, one law for the whole European Union, is not necessary for the public sector. and that the regulation would not do justice to the differences between the member states, especially in the public sector. In my view, that would not be a good idea to exclude the public sector, for practical reasons and for principal reasons. From the perspective of the citizen, it does not make any difference for a citizen whether his or her data are processed by public or private instance. For instance, you have private hospitals and you have public hospitals. It does not make any difference for a patient whether his data are processed, are kept, are stored by a public hospital or private hospital. That would not make sense if we talk about protection of the citizen. So for us, there should be no exclusion of the public sector. I can talk long about that, but I don't have the time for that. Then the exception to the EU institutions. Within the Parliament and the Council, we know there is quite some opposition to this exception. And there are proposals that the exception be lifted. That's also what you can read in the text with Libe Committee agreed upon. We, as EDPS, recently wrote a letter to Vice President Reding supporting the idea that the EU institutions should not be excluded. What, however, I think at this moment is most important, what counts is the result. I think it should be ensured that the same level of protection for the EU institutions is guaranteed as it is for the rest of Europe. That's the most important point. That may be through a different instrument, although that's not our main purpose. But for us, I think the most important is that there are similar rules, exactly the similar rules for the EU institutions as they are for the public sector in the member states and as they are for the private sector.
Well, a small comment from my side. Well, it's a question of consistency. If you make differences in this field between the EU institutions and you consider a lower level of protection for the EU institutions, this would be a bad example for Europe. I would say we need at least a common level. Perhaps there might be some differences in specific instruments, but in general it must be the same. The Commission tabled the proposal on Europol, for example, and this was a very low level from my side, from my perspective, of protection there, lower than the directive for the proposed directive for police and justice for the European member states. So we need consistency on a high level. That is, I think, one basic need.
If I may add to this, I fully agree to the remarks by Peter Schaar. And it would, for us, be very good if, for instance, Europol and Eurojust were included in the main system, that the same rules would apply to Europol and Eurojust. So that's something we would ask the Commission to do.
The Commission, Marie-Hélène.
Thank you, Peter. I was looking for a micro. No, just maybe to reply very briefly on some of these points. I don't know if it's completely appropriate at share. Maybe I should do at the end, but let's do it now. Maybe on the public sector, just to support what Hielke said and to say the notion of public sector, first of all, the public sector is part of the internal market. So there are many policies in the European Union which are based on public sector activities. That's one point. And another point, which is an important one, is that public sector in one member state, and Hielke said that, is not the same as in another member state. So if you compare to take countries which are from a traditional perspective different, France and Germany, they would have activity, I would say in France, more in the public sector, and not Germany, I'm sorry, UK, more in the private sector, to put this in perspective. But just I wanted especially to comment on the EU institution. From the Commission side, we believe exactly what has been said. The same rules should apply, and the Commission has issued a declaration to that extent to say that it would present the necessary instrument to ensure that all the rules would apply at the same time. But the discussion about should this be in the same instrument, there are many difficulties with this approach. So this should be a separate instrument with exactly the same level of protection.
Thank you very much. Another question addressed to Hielke. It's relating the question how far the same requirements should be addressed to the different forms and of data processing. Should there be more differences in the light of a risk-based approach? For example, if you use data that are not directly personal related, like pseudonymous data, should there be other requirements for the processing of those data as for the processing of data that is related directly to a specific individual?
Thank you very much. I understand your question as relating to the risk-based approach and also to the principle of accountability, which in our view is one of the most important innovations in the new instrument. Article 22, which is now further clarified in the discussions in Parliament and also in Council, I think is a very important new general instrument for data protection, which means basically that we try to shift the responsibility more to controllers who should not primarily focus on compliance with bureaucratic requirements, but should guarantee a result which provide that the individual is protected where this is needed. And where is that most needed is where there are the biggest risks. We see that the Commission proposal in this respect is still, may have been still be a little bit too prescriptive. Much of discussions goes about it, but we also have to keep in mind that some prescriptiveness is needed. You need to have precise rules in order to protect the citizen. On the other hand, you need also leave flexibility to ensure that controllers and processors, that they really focus on the most important things, which is to ensure protection where it's needed. So there's difficult for philosophies which has to be brought together. We pleaded from the part of the EDPS strongly on accountability and also think about ways forward about risk-based approaches. But risk-based approach is not such an easy concept. We see quite a difficulty how to measure risk. We see that there's a lot being done in the course of the legislative process and also in academic circles. We see that it's not so easy to see what is risk, how to define it. The Irish presidency did a lot for it. And also, if you look at the text which is agreed by the Libe committee, you see Article 32A, which lists a number of specific risks. Interesting article to read, I would say to all of you, Article 32A, because it combines different things, some objective factors like the number of data subjects potentially affected, but also very subjective things as the risk to a person's privacy, sensitivity, issues which are not so easy to define. For me, most important is that we keep in mind that we should look forward how to define risk, but also keep in mind that this regulation cannot fully define it itself. It's too complicated, and the regulation has to be working into different fields and different areas, on internet, on big companies, small companies. Those are big differences. But it would be good if the regulation gave some indicators of what a risk is, and then further guidance should be given by the European Data Protection Board, for instance, or by delegated or implementing acts. The thinking about risk is still quite immature, and I think one of the examples where you don't know exactly how that will work is the example just given by Peter when he talked about pseudonymous data. Pseudonymous data, if you use them more, it lowers the risk for data subjects normally. But on the other hand, new techniques allow re-identification of data. So it's not as black and white as it is. So it's quite a complex area. So we must find some ways in which we define risk well in the new regulation without having the idea that we solve everything in the regulation itself. And further guidance in whatever form later is needed.
Thank you very much. The next question is addressed to Mario Oetheimer from the European Fundamental Rights Agency. I want to ask you about how the individuals can get access to remedies if there are some data protection breaches. You published just a report on this issue. Please take the floor.
Thank you, Mr. Schaar. And also I'd like to join my thanks Hielke to the organizer, and I'm very pleased to be back here and in fact to distribute this report that was published just today. In fact, you have the first to see it, and I hope that it will provide some solution to the bugs that are still remaining. Now, let me you have also received, I think, a summary of our findings. I'll go very briefly through our key findings, and you'll see that in the context of remedies, I believe that lots have been achieved in the proposal, both by the Commission and the Parliament report, but I would like just to highlight some further enhancement possible that would also respond and echo the Fundamental Rights Agency's findings in this report on data protection remedy. So very briefly, just for you to understand, we put this project really in basically referring to two key fundamental rights. Marie-Hélène was referring to the improvement of fundamental rights through the data protection package, and this project is really based on Article 8 and 47 of the Charter. And I think it's very important to repeat this, because Article 47, of course, is about effective remedies, and enforcement, fundamental rights without a proper enforcement is almost meaningless, as we know. So we went basically to, in about 16 member states, to interview more than 700 people. Half of them were victims of data protection violation, just to assess what they did after such a data protection violation, and what they could do. The really first fundamental finding is that, first of all, these people only very rarely turn to court. Therefore, the entry point to a remedy are the data protection authorities in member states. And finally, the most striking result is that the reason probably also why they don't turn to court is that they have very little support around them. NGOs are only very few, although they could play a tremendous role. Lawyers are only not very present, and judges are not specialized most of the time. In fact, we had a terrible difficulty in our fieldwork research to even find judges, lawyers, NGOs who would be ready to answer our questions. But to cover it all, the overarching result is basically a total lack of awareness about rights. Data protection is not known among individuals, and this is a really serious problem that needs to be tackled. So we have tried to, together with the Council of Europe, in fact, to develop such a awareness-raising material in the form of a handbook that you all have in your bag, and I hope that it will, to a certain extent, contribute to awareness-raising. But now let's come to our topic. Basically, as I said, the Commission proposal is going clearly in the right direction in improving the access, in strengthening the data protection authorities, underlining the need for them to act quickly, providing them with sanction rights that the Parliament has also improved, and of course ensuring that the complaint procedure is free of charge, which is a very important reason why, in fact, DPAs are so demanded or successful from an individual's point of view. Now, from the Parliament side, what I would like to underline and come back to the importance of Article 47 of the Charter that now is proposed to be really included in the text of the regulation. I think it's very important. But more fundamentally, on a redress mechanism perspective, I think the decision to open up the possibility for association acting in the public interest to defend individuals, it will make, I believe, a fundamental difference if this suggestion is kept in the final text. Now, I know that we're talking about solution on this panel only, so I also want to underline that we're going certainly in the right direction. For example, and I have 7 quick points to make, the collective redress is certainly a very important thing, and I hope that the negotiation will maintain the level suggested by Parliament. As I mentioned, there are also accompanying measures that need to be taken. The lack of awareness among lawyers and judges need to be addressed, maybe not directly in the regulation, but if you look at the recent report, in fact, published by the Commission last week on the implementation of the Equality Directive of 2000, you will note the efforts that were made at the time through EU funding to train judges and lawyers. Why not start now already thinking about such an important need to have serious targeted projects? I know that at national and member states level, there are loads of training going on, and we know that, for example, ERA and EDPS is also involved regularly in training. But what would be really necessary is to assess the needs in many countries. Again, I mentioned briefly the need to develop the civil society circle, and I believe here again, accompanying measures needs to be put in place to make sure that in every member state, individuals can easily access to NGOs that can help them, and this same NGO and association that will be able to bring their cases in front of DPA or court if need be. The regulation refers to the adequate needs, financial human resources needs of DPA. This is, I think, tremendously important and hopefully will need to be kept in that way or even improved and underlined. I think that's in order to make sure that we have data protection authorities can really take up the challenge and enforce the rights. Likewise, I think I can underline the importance of the increase of the sanctioning rights of DPA that also our study shows is very important so that DPAs are taken seriously by individuals who decide to actually complain. There is an element that I would maybe throw in the debate that was mentioned and I think could be really very important, and I don't want to propose a solution on this because the data that we are publishing today does not really provide a solution, and we would probably need to look into it more. It's the question of the burden of proof. Many individuals were basically raising the problem of showing to DPAs or even courts that they were victim of a data protection violation, mostly in courts, of course. And this, I think, again, could be addressed in the course of the negotiation to see whether we could find a solution to, again, facilitate the access to remedies. My last point, Chair, which unfortunately was not totally addressed by the European Parliament, is the question of the independence of the nomination of the head of DPAs. It's a recurrent theme at the Fundamental Rights Agency. We always underlined that in order to make sure that the independence of DPA is taken seriously, also from an external perspective, we need to have a very pluralistic nomination procedure. It might be a detail in the overall reform, but I think it's a tremendous important symbol that if the nomination procedure could go just a bit further than the current requirement from the court in Luxembourg, for example, and really put in the text the level of ensuring the pluralistic nomination procedure. I think it would be very important. And again, in some committees in Parliament, in fact, some language was suggested that would be quite easy to my mind to be entrenched in the legislation.
Thank you very much. May I add a remark to your last sentences? Well, at least we need transparency about the procedures. And sometimes we have the impression that there's a lack of transparency even on the national as on the European level. What are the criteria and who is deciding about? But I will not go into the details. Well, we come now to one very interesting question, very important question, that is one basic idea of the reform. That's a one-stop shop mechanism. One-stop shop means that there is only a single point of contact for every data controller. And although this data controller is established in different European countries, this controller should have contact only to one single data protection authority, and this single data protection authority should have a decision power, a final decision power on questions related to this controller. There are a lot of questions related with this model. First, how could we define who is the competent authority? How can we prevent that the controllers do a kind of forum shopping and go to the authority where there's a light regime, or where are friendly officers? So Christopher Kuner is an expert who can answer these questions.
Thank you very much, Peter, and thank you very much to the organizers for inviting me. When I saw the title of this panel, which I think must have been set a year ago, I thought it was very optimistic. Fixing the last bugs, it sounds like you have a few problems with your DVD player and you just need to work to fine-tune them a bit and everything's fixed. Actually, I think at the moment the bugs that we're looking at are very big with regard to the data protection reform. And I was looking at some titles of some horror motion pictures, and I found titles like Attack of the Giant Leeches, The Giant Spider Invasion, Attack of the Killer Bees. I think these are the type of bugs we're dealing with now. They're bugs that are quite big and quite menacing. We have been directed to be very short, to be focused in our presentation, to focus on solutions. I will try to do that and be brief also. To follow up with just one sentence on some of the points already made, scope of the directive and the regulation and the public-private sector issue. Anyone who's interested in this, which I think is all of us, should look at an article that was just published about a week ago in the Cambridge Yearbook of European Legal Studies by my colleague in Copenhagen, Peter Bloom, and Christian Svanberg, who's a Danish government official who wrote a very interesting article exactly on this. With regard to lack of awareness of lawyers, of data protection among lawyers and judges, one thing that's not talked about that should be, I think, developed more is to talk to those of us who teach this subject at a university level. I've taught now in Austria and Denmark and Copenhagen, in the UK and Cambridge at the level data protection law. There's a complete lack of, well, there's extreme interest among students in the topic, but there's a sometimes we have to fight a bit among some of our colleagues in the faculty to get the recognition of this topic because it's a bit unconventional. And I think what this results in, most judges in Europe have never had any exposure at all to this subject. So we need to also raise the level at the university level. I'm not speaking, of course, about Tilburg and VUB, et cetera, the universities that have sponsored this conference. That's not a problem for you, but for many of the rest of us. Awareness, and then finally nomination of DPAs. Aha, yes, interesting topic. I won't go into that beyond saying that I think that we need to look not only at the legal issues, but the political issues. We have a situation now with regard to the EDPS being weakened. I think all of you should be talking about that. It's really something that if it was happening in a third country, I think the EU would be protesting it, but that's not happening. So I will now go into become more technical. The one-stop shop, I've said from the beginning, is a key element of this proposal, and it's something that I think the Commission deserves a lot of credit for. It's really a huge added value of the regulation. However, it's encountering a lot of political opposition and also technical opposition. And the main, I tried to boil down the issues into two. I think there are two main problems. And the solutions, the potential solutions, of course, have to be seen in relation to the problem. So problem number one, I think the cases where the one-stop shop is invoked is not very well defined. And I'm talking not just about the Commission proposal, but whether you look in the Libe version or the drafts of the Council, it doesn't really matter. And I don't think we're talking about one particular version here because, you know, there's so many versions out there and they're very different. So we need to have a clear test for when is the one-stop shop invoked. At the moment, it's a bit vague. I think the one-stop shop should be limited to specific cases. So when there's a cross-border issue, that's the case for the one-stop shop. If an individual is just asserting their access rights involving their data in a particular member state, that can be dealt with by the local DPA. I don't think we necessarily need the lead DPA concept here. So we need a clear catalog of powers that attribute competences to the lead DPA, such as monitoring powers, investigatory powers, corrective powers, and authorization powers. The second problem, and this is what was raised in the opinion of the Council, the head of the legal service of the Council, which I know is supposed to be confidential, but I think that means in Brussels everyone, even the man selling newspapers on the street has it, where he said actually this has to be a one-stop shop for individuals and not for companies, and I agree with that. So this cannot result in extra burdens on individuals. I think we could solve this in two ways. One is by sort of reversing, keeping a lot of the concepts, but turning it on its head and saying by default, individuals should always be able to go to their national DPAs, and that the local DPAs are primarily competent, but then they would be forced to get the lead DPA involved in certain cases when this is necessary. At the moment, it seems to me the proposal from the Commission in particular is sort of works on the reverse, that the lead DPA seems to be competent by default, and I think this is the basis for these objections about fundamental rights. I'm sure that my colleagues may not agree with me, but this is the impression that one gets. So we need to have a corrective mechanism so that there's no extra burden on individuals. The other solution, of course, to this would be to have, and this was mentioned in the advisor's memo, would be to have a European data protection agency and to have one agency supervising data protection around the EU, perhaps with local offices or local branches. Now, this would be, in some ways, I think it's the best solution and the cleanest solution, but it's clear there's no political will to create a new agency. I think this would also possibly demand a change to the treaties also, which, of course, would be very, probably impossible. But this would be maybe in some ways the cleanest solution. So I'll turn the chair Microphone back to you.
Thank you very much. Marie-Hélène wants to add some words.
Thank you. Just maybe to comment on some point, not to come at the very end. I think in the points which have been made previously, there was one point which I could not agree more, which that not everything can be agreed in the regulation. And I agree on that. That's a very important point. This means that it will have to apply to many sectors. There will be need for codes of conduct, guidance, case law, and so on. So all single case that will happen in 10 years should not be defined in a prescriptive way in the regulation. So there is room for interpretation, and we should keep room for interpretation for the future to apply this regulation to new situations as they occur. And that's very important. And the governance is very important there because the data protection authorities, for instance, in the framework of the board, will have a lot of competence to issue guidance and so on. And the Court of Justice, I'm sure, will become more and more involved on data protection. We see already that the number of cases in the Court of Justice is increasing in a very, very important way. That's one point. Another point which was raised, which I found very interesting too, was the fact that we should have strong DPAs and DPAs with Ts. So the independence of DPA, it's a very important factor. It's protected by the treaty. We have launched several infringements in this matter, and it's important that they have Ts and that they have means. And that's a very important element that I wanted to underline from the intervention. I'll try to be short. The next one is the burden of proof. I think that was one of the things which was very important when we drafted the proposal, to be sure that the burden of proof would be simplified for the individuals. And the way provision of it drafted takes this into account. Last point I want to make is on the one-stop shop. I think there is something we need to remind in this discussion, and I'm more optimistic than the majority of the panelists here, because I think the work is improving and there are a lot of discussions which are necessary for people to understand all the elements of this. But I'm more positive than telling this is so complex, so difficult. No, I think we are progressing there. But the data protection authorities, they work together. So they already work together. So when we speak about a one-stop shop, it's not one authority in one member state imposing its decision to another member state. It's people working together, and one as an EU head and becomes the leader and has to take the decision. And I have to say, I disagree completely with Chris regarding the individuals. The proposal of the Commission is clear. The individual can select the DPA where he wants to go. And that's very important because it's part of the protection of the fundamental right that the people can go where they want, and that the cooperation between data protection authorities does not change anything regarding the fact that your interlocutor is the data protection authority that you have selected. That's a different matter.
Thank you very much. One additional remark. There are a lot of questions related with the cooperation procedures and the consistency mechanisms proposed by the Commission and even by the European Parliament. The fear of many DPAs is that a very strict one-stop shop system could exclude them from decisions relating and concerning their own people. And this might be a problem. And therefore we need a clear understanding and clear procedural rules about how we come to common binding positions. It is clear that there should be, I think it is broadly accepted, that there should be a single point of contact for the companies. But what's going on beyond this single point of contact? How will be the decision findings? This is the crucial question, and I think the discussions are going on there. As I have learned, the Council have had a lot of meetings only on this issue. I don't know whether there was a result yet. So, I want to address the question of one-stop shop to Thomas, who has another perspective from the commercial side.
No, thank you, Peter. Yeah, I think from an industry perspective, I think the regulations brought in three major advances. I think the first one, I already mentioned it before, was the fact that it was a regulation, sort of one single set of rules across Europe. The second was really about the one-stop shop, and I think like one cannot look at one without the other. I think they are both, it's two sides of the same coin. And without one, we can't have the other, and vice versa. And from our perspective, it's a key positive. It increases clarity. It makes easier compliance for companies. It reduces red tape. There's less confusion of having to deal with multiple compliance rules. This is something that the Commission has really been pushing for from the beginning, and I think we want to commend Vice President Reding for her full support on the one-stop shop, and she has made it one of the main achievements of this regulation. To come to the attacks on the one-stop shop, and first, and as Chris rightly pointed out, I think the legal service opinion from the Council is quite worrying and calling into question the fundamental basis of the one-stop shop. That it's not an internal market issue; it's a fundamental issue. Hence, this cannot work. Other calls that there's not enough proximity to the data subject, and I think I want really to echo the points that were already made. Having a single point of contact for a company is very important, and it also allows for more cooperation between the single DPA and the company. They can get to know one another very well. They can, they're engaged in constant discussions, constant dialogue that can, try to bring solutions to problems, even hopefully before they can arise. So to try to preempt a situation from escalating and having to say, okay, who's responsible now, who does what, et cetera, et cetera. And from the data subject's point of view, the solution that was already highlighted, that there are two DPAs. The lead DPA, which is the one where the company's one, works closely with the DPA from the individual. So one knows the company very well, knows how it operates, and on the other hand, you have a DPA that's closer to its data subject, who knows exactly what the problem is, and they can something is doable there. And I think I really want to re-echo the point that I made at the beginning. I think this is not a bug. This is a major issue. It's a central part of the regulation. This is not something that can be fixed with a simple wave of the wand. It has to be done. It's with enough political will to push this forward. And a review that would not have the one-stop shop addressed properly. And we can always fine-tune it. I think guidelines moving forward, etc., is possibly a way forward. But this clearly needs to be in there. And there are ways that can happen, and I think it will come over time. I think we cannot fix this issue in a very simple, straightforward manner today for the next 20 or 25 years. And I just really want to finish this in echoing the comments from Vice President Reding that she made back in December, that a regulation without one-stop shop is not worth the effort.
Thank you very much, Hielke.
Yeah. I think the last conclusion I could only share, but to come back to one point which Christopher Kuner made, and which for me was something quite crucial. He said the citizen must always go to his own DPA. There must be this close link with the citizen. When we talk about, of course that's important, but when we talk about the one-stop shop, one thing we should keep in mind that what one wanted to achieve, that is, if a processing operation, for instance on the internet, affects data subject individuals in a large number of member states, that there's only one decision in the end that comes out and not 20 different decisions. That's something we always have to keep in mind, I think, when we talk about the one-stop shop. The other thing is to ensure that there is involvement. It must be sure that what happens during the procedure is not an exclusive thing. If there is a lead DPA appointed, it's a leader. It's a leader of a team, a group of DPAs. It's not the one that does it on its own. That's the second important element of this system. When we talk one-stop shop as an entry point, that can be useful for industry. I understand, of course, that they have only one interlocutor. The citizen should also have one interlocutor. That does not necessarily have to be the same. But it should be ensured that all the involved DPAs, because the citizens in different countries are addressed, are affected, that they are all involved in the process. But the end should always be one decision, because otherwise we don't get what we want. We don't get the regulation, one law in the members, in one law for all needs also enforcement for all.
Thank you very much. I share the result that we need a kind of one-stop shop, but we have to be aware that in some cases there are other means and other procedures that are appropriate, especially on the local level. If there is a video surveillance carried out by in the premises of an institution with the main establishment in Paris, and it is the question is related or addressed to the to what this company is doing in Berlin. It doesn't make any sense, I would say, that that the Berlin Data Protection Commissioner goes to the French CNIL and asks the CNIL how to deal with this video surveillance camera. I think this would be a very bureaucratic system. So we have to distinguish between cases that need this one-stop shop mechanism and other cases that could be handled on the regional or national level.
I think,
Chris?
I think that's what Chris Kuner actually started with, which was a very good point in which I fully support him. But
Yeah.
No, just to make a short addition to what I said, I think there also are grounds for optimism, and one source of that for me is the Court of Justice. When you look at the court now as it's been interpreting the Charter of Fundamental Rights and the Lisbon Treaty, and it seems to me the court has been taking much more of a good European standard, and what we need to do also to help solve the one-stop shop is to further develop a European concept of data protection. I refer in particular to the case of Meloni, which, if you're not familiar with it, C-399 from 26th of February, and as summarized by Professor Weiler, the holding of the court was a member state cannot disapply a union measure which conforms with EU human rights standards for violation of its own human rights constitutional provisions. This means if we get things right at the EU level and we build in strong protections for fundamental rights, then a one-stop shop should be possible, and we should be able to have European view of data protection and not descend into all sorts of individual member state interpretations.
Thank you very much. Marie-Hélène.
Just one minor sentence. When we speak about one-stop shop, and I've heard the comment from the business from different people, I think there is one element which has not been mentioned. Consistency, it's also important for individuals. People move, traveling in Europe, and when it's not appropriate that if they are in one country, they have one set of data protection rights, and if they move to another country, the rules are different because data protection authorities want to keep their decision for the local citizen. It's important to work together. We are more and more in a globalized world. People need to have consistent protection if they move across Europe, if they go on a holiday, if they travel, if they move as students. And that's very important point of this debate. But regarding the specific points which have been made regarding that some issue can be dealt with at local level, there is no disagreement from the Commission on this point. But when there is a boat, there should be a captain. And to be a captain, you need to have some powers.
Okay. Thank you very much. We come to another important issue. It's a question of data transfer not within the European Union, but from European member states to third countries. The regulation provides us with different means, with different instruments, how to deal with data transfer. I want to ask Thomas about his opinion on this.
Okay, Thank you, Peter. No, I think, as mentioned before, that there were three main positive elements from our perspective in the regulation. Regulation, the one-stop shop, and the third one was the recognition of the importance of the international data transfers and the strengthening of these international data transfers. And I think, one thing that we should not forget when we look at these things is that we live in a sort of the global digital age. And everything is now digitized. Like data is everywhere. Data is produced every second in enormous quantities. And global markets are actually key for the viability of companies. Now, it's true for European companies who have been developing here and exporting their services, their products around the globe. And the fact that they are able to transfer data across border is extremely important. It's also extremely important for European citizens to benefit from new products, new services, new tools that are being developed outside, that they can come and reach them here in Europe. Now, if you lock companies into specific markets, so data cannot leave the European Union, or data cannot come into the European Union. There you create problems. You build walls. You build fortress, which is not something that is actually even imaginable in our global digital age. So something needs to be done. And I think that the Commission recognized that the importance of this data transfer. They were a number of, the existing mechanisms were strengthened. There were other calls to move this forward. And the EU prides itself in its data protection system, in its data protection rules. And I think the data transfer existing in the 9546 have actually exported the EU rules abroad already. When we look at granted, it's a small number, but the adequacy decision has granted 6 non-European markets with the same rules that European citizens, European data subjects benefit today. You can argue that through the safe harbor, American citizens also benefit from EU data protection rules from the companies who are certified and compliant with these rules. Things can be always improved, and it can always be better, more safe, more transparent, more efficient, etc., etc. But I think the importance of the data transfers is key, and it's been recognized by the Commission, but our concerns lies with what we're seeing at the moment, especially in Parliament. There are calls to cut off the entire range of data transfers mechanisms available today, from the BCRs to be suspended, from certain adequacy decisions to be revised in the very short term, from the safe harbor to be rescinded, tomorrow if possible. I think this is clearly worrying, and this is deeply depressing from a business perspective, not because of course businesses would suffer, but ultimately the ones who would be the most affected by this would be the European data subjects, who wouldn't be able to benefit from all the great advances and great technology that are being developed and put to market. For the European companies who won't be able necessarily to transfer data to reach other regions. I think when we look at the world, in the global digital age, Europe is not self-sufficient. We need everything, we need every part of the world to function, to live, to prosper. And cutting off data transfers is a terrible, terrible idea.
Well, may I ask a very specific question to a new instrument proposed by the European Parliament? It's the new Article 43A of the regulation.
Of course.
The proposal. Well, this article says that if there is a request of a public authority of a third country, the company has to ask the competent data protection authority in Europe to agree on, to approve the data transfer. What do you think about this instrument?
Well, I think this instrument, this proposal by the European Parliament, is actually creating a deliberate conflict of law. It is putting companies in a situation where, either way they move, they will be subject to liability and penalties. And I think this is not the proper answer to this, because on the one hand you have to abide by the data protection rules, and in this specific Article 43A, I think we're talking about sort of law enforcement, or for the purposes of issues that that call like national security, to have access to data. I think the 9546, the regulation, both have carve-outs for national security exemptions. And I think, in this space, you're having a company, that abides by European rules and that has data abroad and that is subject to request from a law enforcement agency or authority to access data for the purpose of national security under a subpoena. What are they going to do? Are they going to be, subpoenaed, fined in a third country? Are they going to be? It's a conundrum that is not achievable. This can only be resolved by government-to-government discussions, and governments need to sit around the table and they need to find a solution and not putting businesses in the middle. It's a deliberate, as I said, conflict of law that is not solvable.
Well, the problem, I completely agree on the diagnosis that there is a conflict of law, but the conflict of law is not created by this new article. It still exists. We have a common understanding in Europe on the question, what is adequate data protection? And we see after the Snowden revelations that there was a very excessive access to data related to European data subjects by US authorities without adequate, from my perspective, legal safeguards. And therefore, at the end, the adequate level of data protection was not met anymore. So we have to address this question. We should not ignore this. And it is not only related to the United States. It's also a question that comes up with many other legal systems with many other third countries. So I completely agree that we cannot leave it to the companies to decide. I have no solution how they can deal with this conflict, and therefore I have some problems with this proposal. But we need a mechanism how to solve this legal conflict.
Yeah, but then again, I think data protection and the regulation in the 9546 is about, business data. So data held by businesses for commercial purposes and the rules they have to abide to in order to protect their customers, the data subjects. Here we're talking about different scenario where it's law enforcement for the purposes of national security, which is out of the hand of a company, it's out of the hand of an individual, it's out of everybody's control except the state requesting it.
Okay, good. I think we leave it as it is, and we come to our final question about the political aspects related with the new proposal. Perhaps Chris can step in.
Well, I don't want to say much about that. I mean, this is, as I understand it, this is the technical panel, and then this afternoon you have Chris Doxey, Françoise Labaye, et cetera, talking about the politics. I would just say, when we, of course, we can't separate politics from technical legal issues here, and that's the way it should be, because passing of legislation is a political process. That's the way it works in a democracy where citizens can make their voices heard. It's a bit dismaying that I think there is a lot of political jockeying going on with this regulation, and we need to really keep focused on the need to have a new legal framework. We cannot go on forever with Directive 95/46 as for all of its strengths. And I hope that people will keep in mind, sort of show in German, you would call it Zivilcourage, and talking about keeping in mind the European aspect of this, that we need for all of us in Europe a new framework. This is the only way we can be strong. This is the only way we can resist any of these challenges that we've spoken about. That's my contribution on that point.
Okay, thank you very much. Other contributions, Marie-Hélène?
For once, I agree, no? No, that's clear. And as I said earlier, when I heard your point, I think there is room for optimism. So I'm less negative than what I've heard in this panel, but there's some mixed feeling. It's an important topic. It has a lot of impact. They are difficult subjects, but things are progressing, and I would not be pessimistic as I heard by some. And the political panel this afternoon, I'm sure, will tackle this point. The Greek presidency has put this file as a priority, has dedicated a lot of working days on this file, and that's a good signal because there is need for.
Next session will start in 10 minutes.
There is no need for thorough discussion on specific topics, but I think we will get there.
Thank you very much. Thank you very much. We discussed a lot of topics. The one legal instrument, the question of remedies, one-stop shop mechanisms, instruments for data transfer, and we named this bugs. And I am questioning whether this is the right wording, perhaps. These are no bugs, these are features. Thank you very much.